That is the exact fee the city of Seattle billed a local builder named James Vert for adding 4 townhomes to a single residential lot, not for pollution, not for traffic, for building housing in a city that says it is desperate for housing. City Attorney Erika Evans stood at a podium in Seattle City Hall this month and made the city's position on landlords unmistakable. You're going to have to pay the city of Seattle. You're going to have to pay the renters that you took money from. You're going to have to pay up to 3 times the amount of the unlawful fees that you collected, she said, addressing property owners directly. That is the tension this video unpacks. A city government that says it wants more housing, more affordability, and more protection for renters, while simultaneously suing, fining, and feeing the very people who build and manage that housing into financial retreat. How the fees began. Understanding how Seattle arrived at a place where a builder owes 6 figures for a fourplex requires going back to 2016. That year, the Seattle City Council adopted the Mandatory Housing Affordability Program, known as MHA, as the cornerstone of what city officials called the Grand Bargain. Large developers agreed not to challenge new affordability mandates in court. In exchange, the city upzoned dozens of neighborhoods, letting builders construct bigger projects without asking permission first. The program went into effect downtown and in South Lake Union in 2017. By March 18, 2019, the council voted 9-0 to extend it citywide, covering 27 urban villages and centers. Under MHA, developers can pay up to $32.75 per square foot in fees, or set aside up to 11% of units as income restricted. Unlike most inclusionary zoning laws around the country, Seattle's version does not exempt small projects. A homeowner adding a single accessory dwelling unit owes the same kind of fee as a corporate developer. That detail is the root of the current fight. The lawsuits piling up. What makes this particularly sharp is that the smallest property owners, the ones who never sat at the table when the grand bargain was negotiated, are the ones absorbing the biggest hit relative to their resources. Mehret Teshome and Rocco Volker wanted to redevelop their single-family home into a smaller duplex plus an accessory dwelling unit. The city's MHA fee for that project, roughly $36,000. James Vert wanted to build 4 townhomes. His fee, $126,000. Both filed a federal lawsuit in the U.S. District Court for the Western District of Washington in July 2025, represented by the Institute for Justice. Attorney Saranjan Sen, who represents both plaintiffs, put it bluntly to reason, Seattle is taking the land use permitting process as an opportunity to extort landowners. Land use permitting demands are supposed to represent a public impact or harm mitigation. It's not supposed to represent the city's attempt to get something out of the landowner. This is not the city's first time in this fight. A separate Institute for Justice client, Anita Adams, had her MHA challenge dismissed in 2024 on procedural grounds. Her case is now on appeal, with oral arguments scheduled before the 9th Circuit Court of Appeals in September. Sen doesn't expect a fast resolution. Even if we win, which we are optimistic that we're going to win, these things just take so much time, he told Reason. Meanwhile, every single day, the city of Seattle is extorting property owners across the whole city, and in the process making housing more unaffordable for everyone. The math the city can't escape. None of that changes the fact that Seattle's own commissioned research backs up the property owner's complaint. A city-commissioned report found MHA's fees act as a small but important headwind on housing production, and that when a project's return on investment sits close to the go or no-go threshold, the fee can be significant enough to prevent a developer from proceeding with a project at all. The revenue numbers show the damage in real time. MHA fee collections have fallen from roughly $74 million in 2021 to approximately $22 million last year, a drop of about 70% as Seattle's development boom cooled. New multifamily housing applications are now down 94% from their 2020 peak, according to Natalie Quick, co-founder of the Seattle Housing Roundtable. No program sustains itself against math like that. City Hall knew it had a problem. In early 2026, Mayor Katie Wilson's office spent months negotiating an 80% 2-year MHA fee reduction with the Housing Development Consortium, aimed at unlocking roughly 30 stalled projects. Then, on July 6, 2026, the Housing Development Consortium abruptly withdrew its support after community groups said they'd been left out of the negotiations. Mayor Wilson's office pulled the legislation the same day. any chance of a summer vote disappeared. The decision now waits for the fall budget cycle, which runs through November. Here is where the resentment lives. Builders who were told relief was coming had that relief yanked back at the negotiating table, while the fee structure that's suppressing construction in the first place stays exactly as written. The junk fee crackdown. Here's where it gets worse, is usually reserved for escalation, and this is where the city moved from fee disputes to direct enforcement threats against small landlords. On July 7, 2026, Mayor Wilson announced legislation to ban what her office calls rental junk fees. The bill, sponsored by Councilmember Dion Foster of Position 9, would create a specific list of fees landlords are allowed to charge tenants: security deposits, utility surcharges, late payments, key replacement, bounce checks, and parking. Anything not on that list, including pet rent, mail or package fees, and surcharges for using checks instead of electronic payment, would be banned outright. The enforcement mechanism is where City Attorney Erika Evans's quote comes back into focus. Violators face repayment to both the city and the tenant, plus treble damages, up to 3 times the unlawful fees collected. If passed, the rules would take effect in July 2027. Councilmember Foster's office framed the bill as protection against fees that disproportionately hit BIPOC renters, and said it would fund enforcement at the building-wide level so individual tenants don't have to fight landlords alone. Small landlords showed up at the public hearing with a different read. Local coverage from Como described their central worry that legitimate cost recovery charges, not just predatory ones, would get swept into the same net as bad actors, with the same triple damage exposure regardless of intent. The social housing experiment. Understanding the full scope of Seattle's approach to property and housing requires looking at what the city built with its own money, not just what it regulates. In November 2023, Seattle voters approved a measure creating the Seattle Social Housing Developer, a public authority meant to build and own permanently affordable, mixed-income housing directly. In February 2025, voters approved Proposition 1A with more than 63% support, funding the authority through a 5% payroll tax on Seattle employers for any employee compensation above $1 million a year, projected to generate about $50 million annually. The rollout has not gone smoothly. By mid-2025, 2 of the authority's 13 board members had resigned, accusing then-CEO Roberto Jimenez of abuse, anti-black racism, and bigotry, according to the Seattle Times. Jimenez called the conflict growing pains. The board hired an outside investigator. In July 2025, the City Council voted unanimously to approve a $2 million bridge loan just to cover the authority's staffing and basic operating costs while it waited for tax revenue to arrive. On January 15, 2026, the board fired Jimenez and installed Tiffany McCoy, a tenant advocate, as interim CEO. The Seattle Times editorial board, not exactly a right-leaning outlet, summarized the situation in blunt terms last September. Social housing sounds good. In reality, it's like creating a big pile of progressive revenues and burning it. The same editorial noted that the city's nonprofit housing developers, including the Social Housing Authority, face financial instability partly because strict tenant protection laws make it difficult to evict non-paying tenants, meaning the funding model carries its own structural risk from the start, where the accountability question sits. Seattle's current standoff with property owners did not arrive in isolation. It sits on top of a decade of escalating landlord regulation. Back in 2016, the city passed a first-in-time law requiring landlords to rent to the first qualified applicant, removing their discretion to choose tenants. In 2017, the city banned landlords from considering criminal background checks and tenant screening. Both laws were challenged, up to the Washington State Supreme Court, which upheld them. That history matters because it shows a consistent pattern rather than an isolated 2026 dispute. Mandatory fees on new construction, treble damage enforcement on existing rentals, restricted tenant screening, and a government-run housing developer funded by a targeted payroll tax are all pieces of the same governing philosophy, that private property owners, not market conditions or construction costs, are the primary lever city officials should pull to fix affordability. What makes this particularly sharp right now is timing. Seattle's housing market is already strained by interest rates stuck above 6% and rising construction costs nationwide, piling fee enforcement and new liability exposure onto landlords and builders during that same window compounds the slowdown the city says it's trying to solve. Not on construction costs, not on interest rates, not on the underlying market conditions squeezing every city in the country. The city's primary policy lever remains the property owner, the bottom line for landlords and builders. None of the enforcement rhetoric changes the underlying numbers. MHA fee revenue fell about 70% in 4 years. Multifamily permit applications are down 94% from peak. 2 federal lawsuits are actively challenging the fee structure's constitutionality, with one headed to the Ninth Circuit in September. A city commission report already told officials the fees discourage the exact construction the city says it needs. And the city's own social housing alternative, funded by a dedicated payroll tax, spent its first year and a half consumed by board resignations, a fired CEO, and a bridge loan just to keep the lights on. Seattle officials are not short on stated intentions. Mayor Wilson's junk fee bill, Councilmember Foster's enforcement framework, and City Attorney Evans's treble damages threat are all built around protecting renters from bad actors. That goal is not in dispute. What's in dispute is whether a government charging builders $126,000 to add 4 townhomes, while its own housing authority burns through emergency loans and fires its CEO, is positioned to lecture anyone about accountability. $126,000 for 4 townhomes. That's where this started, and it's still the number that defines who's actually paying for Seattle's housing shortage. What do you think happens to Seattle's rental supply if this junk fee bill passes as written in 2027? Leave your prediction in the comments, and subscribe if you want the follow-up when the council votes.